Thank you for your time.
Good evening, everybody, and welcome to this month's presentation of Law at the Library, a partnership between the Evanston Public Library, the Chicago Public Library, and the Chicago Bar Association. My name is Lorena Neal, and I'm the legal literacy librarian at the Evanston Public Library. And we're delighted to have everyone here tonight to discuss this evening's topic, wills, trust, and estate planning. Our presenter for this evening is Carrie Peck, the managing partner of the Chicago law firm Peck Ritchie LLC. I'm going to tell you a little bit about the format for this evening, and then we'll get started. I'm going to introduce Mr. Peck, who will then give his presentation, followed by a question and answer period. So if you have any questions for Mr. Peck, please type them into the Q&A window, which you will find near the bottom of your screen, or you can also use the chat feature to ask your questions there. I will be collecting the questions as they come up, and I will give the presenter the opportunity to answer them at the end. So feel free to add your questions whenever you happen to think of them. If you're having any technical issues or other questions, feel free to direct those to me in the chat as well. Our next Law at the Library presentation will be on Tuesday, April 26th, and the topic will be starting a small business, and I will post links to register for that section in the chat as well if you're interested. Concerning Mr. Peck, he concentrates his practice in trust and estate litigation, estate planning administration, guardianship and fiduciary litigation, and elder law. His clients have included families, hospitals, banks, the state of Illinois, County of Cook, and the city of Chicago. Mr. Peck is past president of the 22,000 Lawyer Chicago Bar Association, is currently a member of the American Bar Association's Commission on Law and Aging and the Elder Law Section Council of the Illinois Bar Association. He has been appointed by the Illinois Supreme Court as chair of the recently created Illinois Supreme Court Commission on Elder Justice. He was retained by the City of Chicago Department of Aging to rewrite the State of Illinois Elder Abuse and Neglect Act. And for over 15 consecutive years, he has been selected by his peers as a super lawyer, an attorney to whom other attorneys would refer their family. And he was named a member of the Leading Lawyers Network. U.S. News and World Report, together with Best Lawyers, named him Tier 1 Elder Law Firm, Peck Ritchie, a Tier 1 Elder Law Firm in Chicago, a designation reflecting the high level of respect a firm has earned in the community for their abilities, their professionalism, and their integrity. Mr. Peck is the recipient of the 2014 Justice John Paul Stevens Award, the Chicago Bar Association's highest honor. He was also selected by IIT Chicago Kent College of Law as one of their 125 alumni of distinction. He co-wrote the books Alzheimer's and the Law and Don't Let Dementia Steal Everything, published by the American Bar Association. And he is a frequent speaker at continuing education seminars for attorneys and healthcare professionals across the country. And tonight he is here to speak to you. So welcome, Mr. Peck.
Thank you very much, Lorena. Good evening, ladies and gentlemen. Thank you for joining us tonight. We look forward to an interactive presentation. As Lorena indicated, if you have any questions, please put those questions in the chat. So we're going to talk about estate planning and trusts and wills tonight. And this is going to be a broad overview in the context of the limited amount of time we have. But I'm confident that with an open mind and a good pen and pencil and paper, you tonight will walk away with a basic knowledge of this area of the law. So Lauren, my able assistant, is going to run the slides for us tonight. Lauren, let's get started.
Just a moment, I'm waiting for the ability to share my screen here.
Thank you.
Okay, you should be all set there, Lauren.
Okay, on behalf of the Chicago Bar Association, Law Library, the Evanston Library, and the Chicago Public Library, I'm pleased to join you tonight and discuss wills, trusts, and estate planning. Let's give it a roll. So let's take a look, kind of the elephant in the room. Clearly, nobody wants to talk about death and dying. It's an uncomfortable conversation for everybody. However, if you really want to avoid leaving behind the heartache and the problems for your loved ones, in addition to your passing, it would be critically important, I would suggest, to get your ducks in a row. Make sure that you have the proper documents completed and you and your family have an opportunity to discuss them and give your family some peace of mind. Parenthetically, critically important, tell your family where the documents are, okay? Basic Law 101. We're going to talk about what is a will in a moment. But if you do a will and you can't find the original after your death, your family can't find the original after your death, in Illinois, it is presumed to have been revoked. And that revocation takes many forms. It could be as simple as tearing it up. But the reality is, let your family know where your documents are. Next slide, please. So who needs estate planning? The reality is some form of estate planning is necessary for everyone. And as you can see on this graph currently on the screen, despite the COVID-19 pandemic, 2 out of 3 adults still don't have a will. And why should you have a will? Because you're going to learn today that if you don't die with the, if you die without a will, the state of Illinois has already written a will for you. What's he talking about? And that is, simple example. If I die without a will and I'm married and I have 3 children, my wife gets half of my assets and my children get half of my assets divided by 3. So each of my children get 1/3 of 1/2 and my wife gets the other half. Now, in the normal course of business, spouses intend to leave all of their assets to their spouse because they intend to provide for their spouse and let the spouse provide thereafter for the children. The children get 1/2 of the assets regardless of age and regardless of need. Next slide, please. So what is estate plan? You can see from this pie chart up here, estate plan has a variety of functions. I think fundamentally most people focus on the distribution of estate assets after death. Understandable. But estate planning has other components: estate tax planning, potential asset protection planning, the avoidance of probate, and we're talking about a post-death probate proceeding, as well as we want our estate plan to include advanced planning for the management of financial affairs in case we become mentally incapacitated, and at the same time, advanced planning for healthcare decision-making should we become mentally impaired, unable to make our own medical decisions. So healthcare management and financial management, 2 different areas that are governed fundamentally during lifetime by what we call powers of attorney. Next slide, please. So what's our goal of estate planning? Well, fundamentally, our goal is much along the lines of my statements in conjunction with the prior slide. We want to protect assets from creditors if we can. We want to reduce or eliminate taxes if we can. We want to preserve our family wealth for future generations. We may want to, during lifetime, provide for support and income, as well as post-death. And we want to manage assets for those unable to manage themselves. if you're stricken with Alzheimer's disease, or you have a stroke and you suffer from what's commonly referred to as vascular dementia that affects your cognitive skills, we want to have a plan in place. Next slide, please. So what can I expect when I do estate planning? Well, if you have a relatively small estate, you're going to focus on how and who your assets will be managed during your lifetime. Again, should you be unable to manage those assets for yourself? Who are you going to name under a power of attorney to manage your assets? Then, as we continue this process of estate planning, under what circumstances does it make sense to distribute your assets during your lifetime? Likewise, how and who is going to make your healthcare and personal care decisions? Where are you going to live if you can't live alone? Who's going to be your doctor? Who's going to be a cardiologist? Who's going to be, should you need surgery, your surgeon? Likewise, we want to focus on potentially if you have young children or you have grandchildren whose parents may have passed away, who is going to be the guardian for your minor children? And to whom are you leaving your assets after your demise? Next slide, please. A large estate has the same considerations, and at the same time, we want to, at that point, focus on the method of preserving assets for your beneficiaries. Beneficiaries could be as simple as the children in your life, the grandchildren, your spouse, etc. And likewise, estate, we want to use whatever strategy we can to reduce or postpone estate taxes. Illinois has an Illinois inheritance tax that kicks in above $4 million. And currently, the federal estate tax is a very high threshold. In excess of 11 million, you will pay the federal government a inheritance tax as well, typically referred to as the federal is an estate tax. Illinois is an inheritance tax. Fundamentally, these are post-death taxes. Next slide, please. So, what is a power of attorney? Why do we have it? And why do we need one? Everybody listening to this webinar tonight needs a power of attorney. You need a power of attorney for healthcare, and you need a power of attorney for the management of assets called power of attorney for property. A power of attorney is a legal document in which I grant authority to someone else to make decisions for me when I'm not capable of making those decisions on my own. So you can see the photograph up here is the Doublemint twins. And many of you will remember the Doublemint twins. So if I grant my agent authority to make decisions, I am the principal. I'm creating a principal agency relationship. I'm the principal, not a school. I'm the principal giving my agent, Lorena, of the Evanston Library, authority to make decisions for me when I am not capable of making those decisions. And you want to name someone as your agent who you trust to act for you under certain circumstances, in essence, your legal clone, okay? Principal agency relationship. I'm the principal. I give my agent authority to act for me under certain circumstances when I am not able to do so. Next slide, please. Are we okay on the audio? I see a number of comments that we're having some trouble on the audio. Anything I can do to assist, or should we get rolling, Marina?
It seems like there might be a little static on your end, on the microphone that you're using. I don't know if maybe having it a little further from you would make any difference or not, but I can still understand you through that. It's just a little bit of buzz.
Is that better?
Yes, thank you.
Okay, my pleasure. So you can see on the slide up on your screen presently that the first power of attorney we're going to talk about is a power of attorney for property. Now, a power of attorney, again, is a lifetime document. This is a document that I'm suggesting everybody that can hear me or see me tonight at this webinar needs a power of attorney for property and a power of attorney for healthcare. The term property does not mean exclusively real estate. It is a generic term for assets. It's intangible property. It is property you can touch. It's money, it's cash, it's stocks, it's bonds, it's coins, it's your house, it's your condo, it's your car, okay? Power of attorney for property. So once again, I name an individual. I name Lorena to manage my financial affairs when I'm no longer mentally and or physically capable of managing my own affairs. And why do I want to do this during my lifetime? Again, this is a lifetime document. This document dies when you die. When you take your last breath and die, power of attorney gone. No longer valid. And why do we want to do this? Because if you don't have a power of attorney for property and or you don't have a power of attorney for health care to make health care decisions when you're not capable, it's quite likely that should you suffer a catastrophic illness or have a sudden, for example, once again, a stroke, if I have a stroke and I'm not able to make decisions and I have no planning of any kind, I have no powers of attorney, and we'll talk about it in a moment or two, no revocable living trust, then my relatives have no choice but to file a lifetime probate, a guardianship, to determine, do I need a guardian appointed by the court, it could be family, to make decisions for me regarding the management of my assets or my health care. So tonight we're talking about two types of probates. A lifetime probate, which is a guardianship. Does an individual need a guardian appointed by the court? The analysis is, does Jane Doe need a guardian? And if so, who should it be? Second question. That guardianship is supervised by the court. It's a public proceeding, and it's a rather cumbersome proceeding that you can avoid with the use of a power of attorney for healthcare and a power of attorney for property. So as we focus on the power of attorney for property, it's particularly useful to manage assets that cannot be owned jointly. For example, a healthcare savings account, an IRA, a retirement plan, or other assets that may not be put in trust. Additional powers under a power of attorney, you could handle as agent, again, principal agent, sign tax returns, file tax returns, establish a Medicaid trust, create estate planning documents subject to some serious restrictions, and so forth. So these are critical lifetime documents. Next slide, please. The corollary to a power of attorney for property is a power of attorney for healthcare. You want to have a power of attorney for healthcare for the exact same reasons you want a power of attorney for property. Should you become catastrophically ill Should you be hit by a bus and unable to make your own decisions, you're taken to a nearby hospital. The reality here is that if you require emergency medical treatment, the hospital is empowered to treat you under exigent, urgent circumstances. But once the hospital gets past that urgent emergency scenario, let's assume you require surgery to save your life. The hospital performs the surgery and you're now in the ICU, the intensive care unit. You come out of the ER, you go to the operating room, you go into the intensive care unit, and life-saving surgery is complete. You are unable to make decisions. Who makes those decisions for you? Under a power of attorney for health care, your agent would make decisions for you. Now, unlike the property management arena, in Illinois, we have what's called the Illinois Healthcare Surrogate Act. And again, for medical treatment, if you're married, your spouse will make those decisions. If you're not married and you have children, you're divorced, your children will make those decisions on down the line based on blood relationship. That law exists only as it relates to healthcare. It does not exist as it relates to property management. So you're going into guardianship court where the court will determine who makes decisions for you. Next slide, please. We're now moving from power of attorney documents that have lifetime benefits and expire when you expire to a last will and testament. Now, what's a last will and testament? Last will and testament basically focuses on who gets your money after you die. In addition, a will designates an executor. So once again, if I have a will and I have an executor, I name that individual. I name Lorena to manage my assets after I die. A last will and testament, ladies and gentlemen, is operative only when you are dead. We frequently get calls at our law firm in which someone says, "Hi, Mr. Peck, I am my uncle's executor. He won't do what I want." And I say, "Well, what is that?" "Well, he won't buy me a car. He won't send me on vacation." And I say to his nephew, "Excuse me, it sounds to me like your uncle's still alive. Is that true?" "Well, of course he's still alive." Well, guess what? As an executor under a will named when an individual is still alive, that executor has zero power. A last will and testament most commonly is admitted to probate. Again, that post-death proceeding in which under the probate law, the will is admitted to probate. We create an artificial tax-paying entity called a probate estate. The court must admit the will to probate. It needs to comply with the laws of probate. It has to have two witnesses. It has to have been executed when an individual is mentally competent and has testamentary capacity. And it will direct the distribution of your assets, the payment of your debts, and likewise the last expenses. A probate document, the probate and the probate of your will is a public proceeding. The law requires under an Illinois Probate Act that a probate proceeding be open not less than 6 months because your creditors can file claims against your estate for 6 months. Most probate proceedings are going to be open longer than 6 months. The probate proceeding also gives an opportunity to individuals seek to overturn your will. and allege that you were not mentally competent and lacked testamentary capacity at the time you signed that will, or you were unduly influenced by perhaps your caregiver or a family member to favor them over the person contesting the will. So last will and testament, basic component to an estate plan. Next slide, please. Now, a revocable living trust is a state-of-the-art method of avoiding probate. This is a significant takeaway, ladies and gentlemen. In Illinois, if you die with assets in your name alone, again, in your name alone, no matter what the composition is of those assets, you will be required, your relatives, your heirs, will be required to probate your assets if you die with assets in excess of $100,000 in your name alone or more. So those assets could be, again, your condominium, your house, cash, stocks, bonds, things of that nature in your name alone. So why do we use a revocable living trust? A revocable living trust is, as it says, revocable, amendable, changeable during your lifetime. It in large measure replaces the disposition clauses of a will. What does that mean? Who gets my money? Who gets my car? Who gets my house? And what we do is we create the Carey Peck Revocable Living Trust. We put our assets in to the trust. We change the title to our assets. So if, for example, we have a Bank of America stock account, we change that so it says Jane Doe, trustee of the Jane Doe Bank of America stock account 12345. This is a private document. It avoids probate. It does not require going to court. It avoids the need for a guardianship, and it allows for both tax planning and planning in terms of, again, the disposition of your assets. This is a state-of-the-art method of avoiding probate. Again, revocable, amendable during your lifetime. A very significant document for the use of avoiding probate. And you retain control of your assets. You name yourself trustee should you become disabled. And when you die, you name a successor trustee. I name myself trustee, and I name a trusted family member as my successor trustee. So this way I avoid that lifetime probate of a guardianship and that post-death probate, which is more commonly referred to as the post-death probate, in which people believe everything needs to be probated. They want to avoid probate. So again, we're talking about two types of probate: lifetime, post-death. Revocable living trust avoids both. Next slide, please. So significantly, with a revocable living trust, the person creating the trust, if I create a trust, I cannot protect myself and my assets from, thank you, Lorena, from creditors. But it allows me to provide for my beneficiaries who may get some creditor protection, and it's an integral part of real estate. Next slide, please. So there are irrevocable trusts. If someone asks you to sign an irrevocable trust, those antennas should go up and wave in the wind. Why do you want to do that? It's primarily used for asset protection and or gifting, but a very, very important, it's irrevocable. You can't change it. Just what it says. Next slide, please. So this is the post-death probate. There's a lot of mythology about probate. In high school, we all studied Greek mythology. This is probate mythology. Again, if you own assets in excess of 100,000 in your name alone, going through probate. Typical delays are up there and the typical costs are up there. Again, public proceeding versus a private revocable living trust. Next slide, please. This is an example of probate. Elvis, the king of rock and roll, lost about 73% of his probate estate to administrative expenses and taxes. He started with 10 million. He ended up post-death with less than $1 million. Next slide, please. So probate avoidance mechanisms, joint tenancy. A and B own an asset together. A dies, the asset goes to B. Typical husband and wife. Husband owns an asset with his wife in joint tenancy. He dies, goes to her. Life insurance avoids probate. You own a policy, you name beneficiaries. It avoids probate, passes outside a probate estate. POD accounts, payable on death. I have an account in my name, it's payable to my wife on death. That avoids probate. Lifetime gifting avoids probate, and living trust we've talked about. Next slide, please. Let's keep going, Laura. So let's take a quick look at poor celebrity estate planning. Okay, the Oscars were this week. Sonny Bono died in 1998, left behind a wife, his fourth wife, and approximately $2 million. He had no estate planning. His prior wife's share filed a lawsuit contending non-payment of child support via their prior divorce. Another person filed claiming he was Sonny's love child, and eventually the estate was settled between his wife and children. An ugly battle. Next slide, please. James Gandolfini, actor from The Sopranos, dies at the young age of 51, has an estate value of 70 million. He loses about $30 million in estate taxes because he didn't plan. Next slide, please. Phillip Seymour Hoffman dies in 2014, leaves behind his longtime girlfriend, 3 children, $35 million estate. He was taxed at approximately $12 million. He lost in taxes, could have been reduced. Next slide. Jim Morrison of The Doors dies of heart failure at the age of 27. He has a simple will, overly simple. He leaves his entire estate to his girlfriend. His girlfriend dies without a will, so Jim's estate and the interest in the group, The Doors, is transferred to the girlfriend's parents. His parents and the girlfriend's parents go to war. Ultimately, he gets his parents get half of the estate. These are examples of famous people who could have done planning and saved their family headaches and a massive amount of money. Next slide, please. So what's your takeaway? You don't have to be famous to do proper estate planning. Mistakes turn costly. It's going to be a public battle. Does your will match your trust, and your trust, match your wishes? Are your assets titled correctly? If you use a revocable living trust, have you funded it? Are you comfortable with the agent you named under your power of attorney for healthcare or property? As life and circumstances change your assets. Change your documents. Don't leave your documents naming someone you don't talk to anymore. Next slide, please. All right, ladies and gentlemen, it's time for questions. Lorena, I turn the floor over to you.
Great, thank you. Thank you so much for presenting to us. Right off the bat, we have a couple of questions about the use of an attorney versus the use of online or pay documents that are available. So when is a legal Zoom will okay, and what are the pitfalls? Or are there other free forms available online that comply with Illinois law for estate planning?
The answer is, I'll tell you quite succinctly, I've never seen seen a do-it-yourself will that's admitted to probate without headaches or not admitted to probate at all, okay? Don't forget, if you use that LegalZoom document, you do it yourself, you won't know of the problems because you're going to be dead. It's that simple. And don't forget, the legislature of Illinois and every state has created a will for you if you don't have one. So if you want to use a LegalZoom and run the risk that it's not effective, bear in mind, as I mentioned earlier, simple example, husband, wife, 3 children, you die without a will, you use a LegalZoom that's not admitted to probate, wife gets half, children get half divided by 3, regardless of age, regardless of need.
Great, thank you. What about for powers of attorney? Are those forms effective for powers of attorney?
I think that yes, power of attorney documents that you can get online are far more effective. And you'll know, or someone will be able to tell you during your lifetime in general if they're defective. Today, when you're admitted to a hospital for a surgical procedure, you will be asked, do you have a power of attorney for healthcare? If you don't, the hospital will say, here, take a look at this one, complete the form. Often with the assistance of either a social worker or in the admissions department. So I think if you have a very simple ownership of assets, very simple planning, you can do that. The documents have complexities. For example, you need to decide if your power of attorney for healthcare or property will be valid immediately, or it will be valid, as we lawyers call, upon a springing document. And that is, in English, it means, Carrie, are you capable of making decisions? And if not, a doctor must certify that the document is effective. So you have 2 choices under those documents: immediate effectiveness or post-doctor determination. Again, they're complex documents, but they can be done with some good assistance.
And just to clarify, if you write a new power of attorney, that immediately revokes the previous one, or is there anything else that needs to be done there?
That document, great question, Lorena. That document must say it revokes the subsequent document. The law doesn't provide for it. So it absolutely must say. We frequently have cases, we call them dueling power of attorney cases. Everybody's heard of the, the dueling pianos. This is dueling powers of attorney. If I do one did one yesterday and I do one today, the one I did today doesn't automatically supersede unless it says I revoke my prior power of attorney dated yesterday.
Great, thank you very much for clarifying that. How much does setting up an estate plan cost on average? And if the cost is too great for an individual, are there any online services that you would recommend, like Trusted Will through SoFi, for example?
What we typically do with legal fees is we ask our clients, we offer all of our clients a no-cost initial consultation. When we determine what we're going to do for them, then we put in print a legal fee agreement. So there's no question, everybody knows what's going on. But I don't quote fees unless I know what services I'm going to provide. And happy to do that. Again, no cost initial consultation. We have offices in downtown Chicago, in Northbrook, and in Oak Brook. So we're happy to talk with anybody who's online tonight, and we'll be happy to discuss fees when we know precisely what we're doing for you.
Great. How are sales of a condo or a house handled if there's still a mortgage on the property as it's going through probate?
It's no different than if there was a mortgage on the house or a condo and the person wasn't deceased. So in a post-death probate, that mortgage is going to have to be paid off. It's likely to be paid off from the assets of the estate. So for example, if an individual dies with an estate worth 500,000 and the mortgage is 150,000 on the condo, and the condo is sold out of the probate estate, 150,000 of the 500,000 would be used to pay the mortgage.
Okay. What is the threshold for what you would consider a small versus large estate?
I would say that probably in the world of 500 and below would be considered small, and probably 500 and above would be larger.
Okay. Do you pay inheritance and estate tax before you can receive the money from an estate?
Yes, I think that if you have a lawyer, the lawyer is going to require that the estate tax returns or the inheritance tax returns be filed. It's a separate tax return. The money comes from the estate before the assets are distributed.
Okay. So I think we may have covered this one. If you have a power of attorney and want to change the order of who is to take care of decisions, how do you do that? And that would be to create essentially a new power of attorney and revoke the old one?
Yeah, I would say
Okay.
that's the safest way. Some people do amendments, but it often doesn't work. I would create a new power of attorney naming your new agent. And you can name agents successively. You cannot name two agents, okay? But you can name
Okay.
child one, child two, child three. If child one's not available, child two takes over. If child two's not available or dies, child three takes over. So that's
Okay.
the method of naming successive agents.
Okay. Do the property and healthcare power of attorneys have to be two separate documents, or can they be combined, and will they be respected in other states?
They will be respected in other states. They unequivocally should be separate documents.
Okay. Are transfer on death and pay on death agreements lawful or enforceable in Illinois, and what are the limitations of those instruments?
I'm not sure what the term limitations means, but payable on death is I own an account, Carrie Peck, and I name a beneficiary. In our hypothetical, Carrie Peck payable on death to Lorena. I die, she gets the money. Transfer on death documents in Illinois, we have a very recent innovation. It's called a transfer on death deed. So you can do a house transfer on death to avoid probate. Critically important.
Okay.
Needs to be signed, obviously, during lifetime.
Okay, so we have a hypothetical or a real situation related question. The person says they do not own a home or condominium, but live in a cooperative they don't own. They have shares in the cooperative. They have a transfer on death instrument and have named their beneficiaries regarding the cooperative. He or she can sell it or use it as their residence. Their funds are in the bank and they've named their beneficiaries. Do they need a trust still?
I think that they probably don't need a trust. Make sure that it's referred to these days as a TODI, T-O-D-I, transfer on death instrument. Make sure that transfer on death deed relates very closely, because as the question points out, co-ops are stock owned, critically important. You got some personal property stock issues intertwined with your realty. So just make sure you do that with a lawyer.
Great. Concerning people who live out of state, is it appropriate to help aging parents who live out of state with estate planning? Can they use an Illinois attorney, or should it be done through that state's attorneys?
I would recommend that it is appropriate to help your parents. Make sure it's transparent. Make sure that all the kids are aware of it or involved, because ultimately it's likely to be challenged if they're not. But you should use an out-of-state lawyer. I'm licensed, for example, in Illinois and Florida. And so if I have parents in Florida, I would want them to use a Florida lawyer.
And if someone owns property in two different states, like Illinois and Indiana, should they have two separate trusts, or can that be handled by a single attorney?
It could be handled by a single attorney. For example, hypothetically, you do the trust in Illinois, put the Illinois property by way of deed into the trust, and engage the services of an Indiana licensed lawyer to do a deed to transfer the Indiana property into the trust.
Okay. So IRAs and retirement plans list beneficiaries. Is that sufficient for power of attorney purposes or no?
I think an IRA beneficiary designation is sufficient, yes.
Okay. Some kind of general questions in terms of, if you die without a will, if you're single with kids, do they come first before your living siblings?
Yes.
Okay, and if there's no will or estate plan, does distribution go to spouse and adult children? Is there any age limitation on the children that are part of the distribution in this kind of scenario?
Well,
It
clearly,
doesn't matter if some of the kids are above or below 18.
yeah, I assumed that was a question. Yes.
Yeah.
Children that are below the age of 18 are considered minors. They cannot inherit property without the creation of a minor's guardianship. So someone's going to have to be named guardian of the children below the age of 18, separate estates for each child, and then they can inherit.
Does the law differentiate between stepchildren and biological children for these purposes?
Very, very significantly, yes. The law is governed by bloodline. So stepchildren, in large measure, need to be provided for in the documents.
Okay, thank you for clarifying that. Can a last will and testament have more than one executor, and if so, under what circumstances?
Yes, a will can have more than one executor, and it's entirely up to the party drafting it as to whether they want, co-executors, two siblings, a brother and a sister, obviously, or an aunt and an uncle, something of that nature. But yes, the law allows for co-executors.
Okay. Is there a minimum dollar value of an estate before it becomes subject to probate, regardless of whether you had a will?
Let's be very clear. The existence of a will doesn't avoid probate, and dollar value, 100,000 or above in your name alone requires probate. So whether you have a will or you don't have a will, it's asset ownership. It's the titling of the assets, the ownership of the assets, that outcome determinative in addition to that $100,000 threshold.
Okay. What are your thoughts on using a small estate affidavit?
If your estate is less than $100,000, the law allows the use of a small estate's affidavit. The affiant, the person signing that affidavit, must also swear there are no creditors of that individual. So that's a tough scenario in many instances, because the person signing is often a close relative and unable to swear that there are no creditors of that now deceased individual.
Okay. That brings us very nicely to our next question, which is, why is protection from creditors so important and so often mentioned?
Well, at the end of the day, you want to make sure that you either provide for your creditors or you're protected from your creditors. Under the Illinois Probate Act, as we mentioned earlier, an individual in a probate proceeding is required to allow creditors to file claims for 6 months. That could be, and it generally is, doctors, funeral expenses, credit card bills, and hospital related to the doctor expenses. So why is creditor protection important? The question is, do you want all of your assets to go to your creditors, or are there legitimate methods of reducing how much money is exposed to creditor claims? With the use of certain types of trusts, in certain circumstances, you can do that. But the reality here is, the creditors are going to come knocking on the door to be paid.
Right. Is there a list that explains how each asset should be titled so it goes into the trust. If an account is not titled correctly, what happens to it and what assets can't be named in a trust?
I don't know of any list, so to speak, but fundamentally, almost all assets except your car and IRAs and 401ks can go into the trust in a generic kind of umbrella response to the question. But,
Okay.
you know,
Does it make sense to do pre and post-nuptial agreements with the same firm that you're doing your estate planning with? I would imagine you would say yes.
yeah, yeah, exactly.
Or with you, of course, I'm sure you'd say.
Okay. Thanks, Lorena.
Someone asked if they have a fairly new SUV, should they put their daughter's name on the title also?
That's really kind of a personal question. Do you want your daughter's, you know, don't forget when you put your name, another name on your title to your car or a title to your bank account, that individual then owns that asset as much as you own it. For example, if A and B own an asset in joint tenancy in a bank, they both have the ability to withdraw 100%. Your question is about a title to the car. If you know, if your daughter's not on the title, the question is ownership and liability. Is she adequately insured? Obviously, don't put anybody on a title that isn't adequately insured.
And with that in mind, that adding someone to your account or your title gives them ownership rights. Is adding someone to an existing checking and savings account sufficient for them to avoid probate?
Well, again, if you're creating joint tenancy accounts, that fundamentally is the issue. Again, if we have a checking account and Lorena and I are on the checking account and I die, she gets the checking account. Lorena and I, during lifetime, have the ability to withdraw 100% of that asset. At the same time, okay, if Lorena, let's change the hypothetical, Lorena is my daughter and she's married and she gets divorced, the question is, will our joint tenancy account between she and I be drawn into her divorce? Okay, important. Choose your joint tenants wisely. Why? They have access to the money, and everything that they get involved in could be asserted that asset belongs to their creditors. There's a real clear creditor issue.
Mm-hmm. Yeah. So someone else asked then, what do you do if you don't have a family or trusted friend to be your power of attorney? What can you do in that situation?
There are a number of not-for-profit organizations, you know, that act as power of attorney for healthcare and or asset management. And, you know, reach out to my office and we'll get you that information.
Great, thank you. Let's see, what is a reasonable strategy to deal with sunsetting estate tax thresholds?
Not sure I understand the question, because there is in Illinois, there's no indication that the inheritance tax is going to sunset. I assume the term is being used as disappearing, like the sun when it goes down. But you know, that Illinois, there's no indication that tax is going down or changing. At the federal level, right now, we don't know that this tax is going down either.
Okay. What happens if someone moves out of state and they have their will, trust, power of attorney drawn up here?
They should have it reviewed by a lawyer in the next state they go to.
Okay. If you have an IRA with more than $100,000 and you've designated your spouse as primary and children as secondary, does that go through probate?
It does not.
Okay.
Beneficiary designation, retirement accounts avoid probate.
All right. Can you speak to digital accounts and record keeping and accessibility of those accounts for the estate planning process?
Yeah, I think that it's critical that you provide passwords and things of that nature to your estate planner. And at the same time, that's going to have to be passed on to your either executor, your trustee, your agent under your power of attorney documents. Clearly, digital assets are controlled by passwords. Without them, you're in trouble. So you need to share that information.
Great. If you have an outdated will, can you use just that will as a template for a new one, or just contact a lawyer and start over? Like if it's 20 years old, for example, at this point, is that a good template, or start from scratch?
It's a good template only if you want to leave the assets in the same amount to the same people. 20-year-old will, I would start over.
Okay. If you have a trust, do you still need a will?
Well, it depends on what kind of trust you have. We haven't talked about a variety of other trusts, but if you have a revocable living trust, then you should have what's commonly referred to as a pour over will. Why? Because any assets that are not funded or title changed into the trust need to pour over post-death into the trust. Those assets need to be less than $100,000, or the concept of avoiding probate is gone.
Okay. If you have a power of attorney that is missing, can it be revoked by writing a new power of attorney stating that it supersedes all previous powers of attorney?
Yes.
Okay. And if you set up a living trust, is it easy to transfer real estate to the trust? For example, you don't have to refinance the real estate in order to do that?
You do not have to refinance. Clearly, your mortgage company is going to ultimately be notified, but at the end of the day, you transfer the real estate by deed. So we create a revocable living trust. We issue a deed from yourself as trustee into the trust. But it is important that the mortgage lender be aware and may or may not have restrictions. You need to check on that.
Okay. Are there any annual fees that are associated with creating a living trust?
No.
Okay. And when would you name your attorney as the executor of your estate?
I think that you would name your attorney when you don't have someone else. If we go back 3 or 4 questions here, someone that is a trusted confidant that you can rely on post-death. And then you would consider naming your attorney as executor.
Okay. Someone asked, using a small estate affidavit, you said the cutoff for creditors is 6 months. If so, how is that enforced?
Using a small estate affidavit, it's not applicable. The small estate affidavit, the individual swears that there are no creditors and or they've been paid.
Okay. In what situations would you not create a revocable trust and only rely on a will?
None that I can think of.
Okay. Can a special needs trust be created years before it's finally funded by a life insurance policy?
Yes.
Okay. Let's see. I'm getting close to the end of questions here. Thank you for being so prompt and knowledgeable with your answers.
Let's go back for 1 second, Lorena.
Sure.
Your question was, when would you not use, I think, a will or special needs trust? That answer needs to be modified by what is the value of the assets at issue in that scenario?
Okay. Can a single parent who was never married with primary custody but not a formal custody agreement engage in estate planning, establishing a trust, and assigning guardianship for the minor child without the input of the other biological parent?
I would say I'm not sure of the answer. Based on what I'm hearing, you don't have the ability to do that because there is another biological parent.
Okay. Adopted children are treated differently than stepchildren under the law. Are they considered part of the bloodline if they've been formally adopted,
Yes.
as opposed to stepchildren? Okay.
Yes.
What about placing property in a C corporation and transferring ownership of the C corporation to another? Can that avoid probate and issues surrounding transfer of real property and businesses?
The question is well beyond the purview of this seminar.
Okay, that would require in-depth consultation. Okay.
Yes.
You mentioned a Medicaid trust. What is that?
Medicaid trusts are generally, they are created. It's a legitimate means of qualifying an individual to get on Medicaid. When you're 65, everybody can get on Medicare. That's government funded healthcare. Medicaid is a different type of program based on need. And Medicaid trusts are irrevocable trusts that are used typically to allow an individual to qualify for Medicaid. Exceedingly complex planning, again, beyond the purview of this seminar.
Okay. Someone has a power of attorney for an aging parent who refuses to create a trust or a will, and there seems to be some onset of dementia. So when is it appropriate in terms of timing to seek a guardianship, and what are the pitfalls?
It's appropriate to seek guardianship if that power of attorney is not going to be effective during lifetime. And you know, we deal with these kinds of situations virtually every single day. You may not have to file for guardianship if that power of attorney gives you the power to take care of mom or dad during their lifetime. On the other hand, you may have to, depending on the circumstances and what powers are granted under that power of attorney. So, you know, my suggestion is you need to consult an attorney on that scenario.
Okay. Let's see. Trying to make sure this is, wanted to clarify, is this for Illinois or does this apply across all states?
What's the underlying question?
I guess.
Maybe the $100,000 threshold?
Yeah, so some of the specifics are Illinois, but I would guess the general advice is, regardless of where you live, get a will or trust.
Well, no. Fundamentally, I mean, this is an Illinois program, so let's be clear. This is Illinois law.
Okay. Let's see. Someone says in California, real estate property value is reassessed on death. So if property is $100,000 when it's bought in 1980 and worth $2 million when you die, the value is set to $2 million. The question is this the same in Illinois?
Yes.
Okay. Let's see. Can an irrevocable trust be revoked by anyone?
Generally only by a court order.
Okay. Let's see. Would the use of stocks in real estate property ownership be a good way to avoid inheritance tax in excess of $4 million in Illinois and $11.4 million in the federal government, as the increase in value gets reset upon the death of the individual?
No, I don't think it's a good method of avoiding inheritance tax at all, because there's all of the items and the method of ownership that you mentioned are taxable.
Mm-hmm. Can biological children who are not recognized become heirs after you die if they apply to the court?
If an individual is a biological children not recognized during lifetime, then post-death, they can go into court and seek to change the heirship, HEIRSHIP, to include them as an heir of the decedent. Yes.
Okay. The person with the California real estate question says, I didn't read it correctly. There's a part about no inheritance tax. Let me see if I can get back to that.
Okay.
So there's no inheritance tax in California, I believe is what you were saying to Gary. If you wanted to restate that, yes. Okay, so the question was, the value is reset in California to the current value of the property, and there's no inheritance tax. So the question,
I'm not sure what the question is.
yeah, so the question is it the same in Illinois then? No inheritance tax when it's reset?
Okay, so he's writing in
Yeah, so he's
Illinois.
asking, yeah, he says, yeah, there it is. If your
Yeah,
property goes
if
up
the
in
value
value.
of the property goes up, then at death, I mean, at death, basically, all of your assets will be valued. If they exceed $4 million, you're going to pay tax in Illinois.
Okay,
I'm not going to comment on what the tax laws are in California.
okay. Can you share any more about toadies?
No, I think that it's a viable method of transferring assets, and I encourage you not to do it yourself. It's a complex transaction that today in Illinois is allowed to occur. It's, again, recent innovation in the law, and you know, I would strongly recommend you consult an attorney if that's something you'd like to do.
Okay. And let's see, can a will control how assets are given to minors even after they turn 18 years old? For example, can you delay distribution until a child turns 25 or 30?
The answer is yes. It's a very, very common provision in a document. In order to do that, you'd need to create a trust under the will to name a trustee to manage those assets and distribute them when that child or children reach the age of 25 or 30. Yes, very common provision in an estate plan.
And then I know we are running over on time here. I'm sorry if I have not gotten to every single question. Is there a way to title small businesses C-Corp or LLC to put them in the revocable trust?
I think that once again, we're getting kind of beyond the purview, but yes, there are methods of transferring businesses, and that's about as far as I'm going to go tonight.
Okay, great.
To consult with somebody, but you know, we can't get into a lot of different complex areas in the basic estate planning webinar.
Yeah, a lot of this is going to require, you know, detailed discussion with an attorney, such as Mr. Peck or someone else that you know and respect. The Chicago Bar Association, with who we are affiliated for this program, does have a lawyer referral service that can help match you to an attorney in your area, depending upon your needs. We have their information on our website. Thank you, Mr. Peck, very much for being so informative and so willing to answer so many questions this evening. Obviously, this is a subject of great concern to a great many people, and I really appreciate your time.
Thank you very much, Lorena, and appreciate the opportunity to appear. And thank you to all who attended, and we look forward to helping you if we can.
Wonderful. Thank you so very much.
Have a good
night.
Have
a great evening, everyone.